So hi everyone, thank you for joining us today. Thank you, Jordan, for speaking. It's great to have you. So Jordan Rodney, is the president of Max People and founder of Rodney Employment Law, a lawyer who brings a unique HR perspective to every issue and case he takes on. Jordan's true passion has and always will be helping people. A risk taker at heart, he left the corporate world nearly 11 years ago to team up with his wife to provide in-house employment law services as part of the Max People service offering. As someone who was fortunate enough to have found great mentors in his career, Jordan is focused on providing thought leadership, and development for those in his firm, his clients, and the legal field at large. Jordan has been quoted and contributed articles in publications such as the Globe and Mail, the HR Professional, Dialogue Magazine, and Lawyers Weekly. He's also a sought-after speaker who presents to members of various businesses and associations annually. A lawyer with a strong reputation and extensive experience, Jordan is proud to maintain many long-standing relationships with clients. His combined passion for HR and law give him a unique perspective, and he is grateful for the opportunity to continue sharing that with everyone that works with Rodney Employment Law and Max People teams. Sorry about that. Thanks again for speaking today, Jordan. Good luck with your presentation.
Thank you, Alex, and welcome everyone. Got a lot to cover here in 30 minutes, but I'll do my best. I had an opportunity to listen to Rishi and Wakita parts of their sessions, and very informative stuff. And I know it's been a very crazy, wild year for everyone around the world. It's definitely been a very wild year on the employment law side. So our business, we work with mid-sized organizations with both their HR and employment law needs. We have an HR Essentials arm, training, hiring, and employment law, which is what I'm going to be talking about today. And what I'm going to cover in the next 30 minutes or so is some key lessons from the pandemic. What are the key takeaways that we're seeing from an employment law perspective, and then just give you a bit of a perspective on an enlightened view of hiring and terminations. So I'm going to get right into it. So the first thing is change, and the greatest danger in times of turbulence is not the turbulence itself. It's to act with yesterday's logic. So the expression, you do the same thing over and over again and expect a different result. That's the definition of insanity. And I think from an employment law perspective this year, the great thing for us is, as employment lawyers, is we were faced with things we had really never seen before. And that made it very interesting and very turbulent. And we kind of needed to go with the turbulence. And that was the very exciting time for us, and something that hasn't really gone away and is not going to go away anytime soon. So it's a good time to be an employment lawyer right now. And I'm sure the other employment lawyers today would agree with me. So one of the key lessons is employment agreements. I've spoken about this for many, many years. This is employment agreements, in my view, and having employment agreements that are valid is really the most important thing that an employer can have in a workplace. And this is for both new and existing hires. And what I want to say is there's never been a time, certainly in my 23-year career, that's been more ripe to introduce employment agreements, because there's a lot of things that employers are able to do now. They have a little bit more latitude than they might have had in the past. So it's something that you should take advantage of. And if there's one thing that you take away from this session, it's that employment agreements do matter. And have yours looked at, make sure they're enforceable. And if they're not enforceable, make sure that you invest the time and resources to have them reviewed and implemented. Policies is kind of the flip side of employment agreements. And our philosophy at Rodney Employment Law and Max People, our sister company, is policies need to be flexible and agile. We're not proponents of putting policies in employment agreements. We think policy should be obviously in an employment agreement, in a policy manual, I should say, and they should be fluid and adaptable to change. So one of the things that we like to talk about is in the employment agreement to basically say that the company has the right to introduce policies and procedures from time to time, and they're subject to change. So what have we seen in the last year? This is going to be no surprise to anyone. We've seen the working from home and working from anywhere policies. We've seen vacation policies being brought up, PTO policies, like paid time off policies, obviously a pandemic policy. We're starting to hear about vaccination policies and, can you mandate vaccinations? I know Wakita talked about that. This is definitely not policies that should be in an employment agreement because they're going to be constantly evolving and changing. And quite frankly, I think it's premature to start talking about mandatory vaccinations, unless, of course, you're in a healthcare, healthcare situation. Wellness, because of the mental health issues, social media. I can go on, but I think you get the point that policies are subject to change. They're going to be flexible over time, and you want to make sure they're in your employee handbook and you're continually training and communicating these to your people. Very important. The infectious disease emergency leave and layoffs. This was a big thing this year, particularly across Canada and in Ontario. What happened was in May of 2020, it seems like so long ago, it seems like 2019, the government came out with a regulation basically confirming in Ontario that temporary layoffs do not result in a deemed termination and do not result in a constructive dismissal under the Employment Standards Act. Now, what I want to say, the important caveat here is that does not prevent someone from filing a constructive dismissal claim under common law. And in fact, in our practice, we saw a lot of files from plaintiff counsel claiming constructive dismissal under the infectious disease emergency leave, but using the common law as opposed to the Employment Standards Act. And I have a very strong view. I don't think a constructive dismissal under common law applies in an infectious disease situation, but I can tell you that this is an argument that we've seen repeatedly. Now, what the government did with the infectious disease emergency leave is that firstly, they extended it till September. That was then extended to January, and it's since been extended to July 2nd, which I've listed here on the slide. So what that effectively means is since March of exactly, Wahida, thank you for clarifying. Depending on which hat I'm wearing, I would agree with you. It's a great point, but I can tell you, Wahida, that we've gotten a lot of plaintiff counsel making that argument in 2020. So what the government has effectively done is they've basically extended infectious disease emergency leave from March of last year until July. And what that's done is it's provided tremendous flexibility and guidance for employers that was completely unforeseen prior to May of 2020. So it's something you want to keep in mind. The other last thing I want to say on this point is there's a difference between a deemed termination, a deemed infectious disease emergency leave, which is basically a temporary layoff that's been converted, versus a voluntary infectious disease emergency leave. Like if someone has to stay home with because their kids' schools are closed, or they have to look after their elderly parents, or they were exposed to COVID. So there is a difference that you need to be aware of. Mental health is another lesson. This was something we were seeing in our practice repeatedly, and it is absolutely skyrocketed. I call it the invisible disability for two reasons. Number one, with mental health, you often can't see it, especially as we've moved to more of a virtual environment. It's even harder to kind of gauge body language, to gauge how people are feeling. The other reason I say it's an invisible disability is because I think leaders and managers in some cases choose to turn a blind eye to mental health. And yes, the stigma is being eliminated. Every month, every year that goes by, it's still a significant issue and something that we see, multiple times every week, both on the employee and employer side of our practice. So I just want to touch on an interesting stat here. 70% of employees reported more anxiety and stress last year than any other year, which I'm sure is absolutely no surprise to anyone on the line. I think we've all struggled to varying degrees in the pandemic. And when, I was working from a personal perspective, I was working from my home office for a lengthy period of time. And I really wasn't able to successfully divide my home office from my work. And I'd walk past my office at 9 o'clock at night and I'd be like, okay, I'm going to go in and send some emails. And I'm not the most disciplined person when it comes to that. So it's something that we just you've heard enough about what you need to do in terms of mental health, but I don't think, and I think there's going to be long lasting implications for people of all ages in this area. So what are the costs for companies that turn a blind eye to things like mental health? Like the iceberg, the direct costs above the water are things like workers' comp and disability, which can be costly. But really what I wanted to focus on is the intangible and indirect costs, which is under the surface. And if you don't deal with those, they're going to fester over time. These are things like absenteeism, lack of engagement, overtime, decreased morale and productivity, turnover. These are significant costs that could potentially damage an organization, both in the short and long term. So it's something that we need to be very attuned to and very mindful of. The last key lesson is communication. There's no such thing as too much communication. I'm going to put on my HR hat here for a minute, because I also have an HR background in addition to the employment law. And what I want to say is, I'll speak about our company. We've had a mandatory daily huddle every day from 9:15 to 9:30 since March 15th of last year. And it's mandatory. We want to see our people. We want to check in. We want to see how people are doing. Ongoing and frequent check-ins with your staff. Pre-COVID was important. Now it's absolutely critical. You have to check in with your people. You have to see how they're doing. You have to keep your antenna up, because people, you might not see them as much and you might not have that physical interpersonal interaction, so you don't really know how they're doing. And it's important for you to ask the questions and be proactive to make sure you're staying one step ahead of your staff. So communication is critical. I'm a big proponent of the daily huddle. It's from the Rockefeller habits and the business concepts of scaling up. So I strongly recommend that you consider that. And by the way, if there's any questions, what he'd asked made a point, but if anyone has any questions, use the chat and I'll try to answer it as we go along here. So I want to spend the rest of the time just giving you a bit of an enlightened view on hiring and terminations. I could have taken other areas of the employment life cycle, but I thought it'd be important to start from like the beginning and the end of the employment life cycle. And I always say to our employer clients, we're not in the business of terminating people, but at times, you have to do it. So let's talk about the development. So first thing on the hiring piece, hiring in a new world, with the pandemic, there's this conventional wisdom and view that, businesses have had to cut back, which is absolutely true. Some businesses, of course, have grown, have skyrocketed, have been very successful. And as a result of both the cutbacks and the growth of certain business, there's been an enormous surge in available talent. I don't think, and I know that Mark runs various, virtual recruitment sessions. I honestly don't think there's been a better time in my career to hire talented people. And on the HR side of our business, what I'm hearing, both from our recruiters and from our HR people, is there's never been so much great talent available than there is today. And because people are looking for different things, and a lot of people have lost their jobs. So really, when clients say, we're not hiring, what I always say to clients is build a virtual bench, be perpetually hiring all the time and interviewing, because you never know what talent is out there. And, I'd be interested to know for the people on the line, if you think I'm correct here, or if you have a different point of view. But I think the available talent right now is higher than I've ever seen in my time. So what does this mean in terms of recruitment? And once you bring the person on board, this WFH and WFA, which of course is working from home and working from anywhere. One thing I want to say here is it is critical that you have unequivocal policies on working from home and working from anywhere. And this is something that you can't have via a verbal agreement. You can't have based on a past practice. You have to actually put parameters around working from home. And I think for someone to say, I'll give you a quick story. I had a young marketing person reach out to me for some advice. They're working at a company. It's their first job. And they asked me for coaching if they can ask their company if they can move to Australia for 6 months and continue to work. They're working remotely. And I said, look, you got a lot of nerve, as a person in your mid-20s to actually ask an employer 3 months after joining the company to work out of Australia. And I said, I think it's premature. And, because perhaps, they're going to start coming back into the office. Perhaps the Wi-Fi won't be suitable. Perhaps they're going to move, perhaps the time change is going to be a problem. So there's a whole host of issues, and the working from home is not the same as working from anywhere. And I had one client say to me, I don't care what time my staff work, I don't care where they work from, as long as they're on the daily huddle every day, and as long as they get their KPIs completed every month. So I think it's up to you as an employer, for you and your clients, to make sure that you have clear parameters and what a working from home situation looks like. The last thing I want to say about this point is the bigger question is not what the policy says. The bigger question is what's going to happen when companies move to this hybrid model or this working from home model, or hybrid model or back to the office model, and your staff are saying, I don't want to come in. I've already had that with multiple clients. And the thing is, they have to come in. There's a job. They have there's a legal obligation for them to come into the office. You've done all the safety protocols. Public health has supported you, and you're ready to go. And I'm not talking about manufacturing or healthcare where you actually, in some cases, need to be on site. I'm talking about situations where you want to have people back in the office or in a hybrid model. The big question, the $64,000 question is, what are you going to do if they're a great performer, but they don't want to come back? That's the question that our clients are struggling with. How far do you want to push it? And that's what I want to leave you with, because this is going to be a very significant issue for HR people, for employment lawyers, and for companies in the next 6 to 9 months. So onboarding, wow, this has changed significantly. Everyone on the line knows there's a huge correlation between effective onboarding and ultimate success in the job. And there's something to be said about onboarding, that interaction, that face-to-face, interpersonal camaraderie that happens. And I can tell you, I'm the first guy to say, 2020 was the first time I've actually hired people in our business. I hired 3 new people in 2020 without actually meeting them before they started. And I met them on the first day when I gave them their, company equipment, their brochures, their swag. And that is very different for a guy like me, who's very much a people person, wanting to meet people and interact with people. Our legal team came in for much of last year, and we're going to start coming in again. But our office has been very much remote, as have thousands of other offices. And again, with the virtual onboarding, the check-ins, the 30, the 60, the 90-day check-ins, setting up a buddy system, making sure that the employee is comfortable, making sure you have the signed employment agreement, they sign off on all their employment policies. These are the things that before they were like important, now they're like, extremely important, because if you don't have these things nailed down, it's going to be problematic for you and your clients. So I have about a few minutes left. I want to talk about some of the important developments in terminations. And I know both Wahida and Rishi touched on this. In these cases, I'll give you a similar but different perspective on some of the cases in this area. So the first one is a violation of COVID protocol. So there was a series of cases, the Liuna case and the Garda security case. In both these cases, well, in the Liuna case, the employee had symptoms and was told to stay home and not report to work. The employee failed to follow the COVID protocols and reported to work. And in the Garda case, the employee was told to self-isolate and elected to kind of flout those public health and company policies and elected to report to work and subsequently tested positive. And in both these cases, these are arbitration. These are in a unionized environment, but I think it's instructive for people on the line and for your clients that both the arbitrators found that dishonesty and misconduct that contradicted both the workplace policies and public health were key factors here to uphold the just cause termination, and the fact that it was done intentionally and willfully, and putting people at the risk of exposure. So these are key cases. I think, my approach is, safety is paramount, and that was before March of 2020. I've often been asked the question by clients, what if our staff don't want to adhere to these safety protocols? You can't screw around with this stuff. This is not like, signing off on a new vacation policy. If someone doesn't want to sign off on safety protocols, you quickly move to progressive discipline, and you progress very quickly. That's my point of view, because we're talking about life and death situations here, and you can't mess around. So the some other cases, the Yi case that came out in the fall and was reported early this year, and then of course the most recent Irotakis case, hot off the press against Peninsula. The implications here on notice awards with COVID. So in the Yi case, interestingly enough, what the court found, Yi was basically terminated in August of 2019, and the court decided that the notice should be determined by the circumstances that existed at the time of the termination, and not the amount of time it takes to find employment. So I think as employment lawyers, we're like, yeah, we understand this was pre-COVID and you can't really predict. Then the Irotakis case comes along. This is a case, a 56-year-old with 28 months of service. And again, he claimed significantly higher severance because he was terminated at the onset of the pandemic in March, so about 6 months after Yi. And what happened is similar to Yi, the court found that the job market at the time, which was March of 2020, was highly speculative and uncertain as to the degree and duration at the time Mr. Irotakis' employment was terminated. What this means is the judge said in March, we really didn't know how bad it was going to be. And I think all of us, I can certainly speak to every employment lawyer I've spoken to, has confirmed that they had no idea this would be going on well into the 18-month time frame. So the judge in this case awarded, didn't factor in the months succeeding the termination, and instead looked at, where things were at the time of the termination. So I think the big thing that's going to come from these two cases, because it doesn't look like there's a huge impact on notice awards, I think the big thing that's going to come from these cases over the next few months is what's going to happen when there's a case decided a year after COVID. And is the judge or the court going to look at notice awards any differently? What I can tell you from a practical point of view is when clients have asked me if let's say it's an employer client and they don't have a good enforceable agreement, I've told them that they should add in the COVID factor as an additional factor, along with things like service, comp, position, availability of similar employment, the Bardell factors. I think they can read in COVID as an additional factor, and that's what I've told my clients. I'm sure that makes the plaintiff employment lawyers very happy, but I think it's being practical, it's being humane, and providing reasonable packages so our clients can get signed releases. But time will tell as to what this looks like. So the next case, this is a case from June of 2020. And arguably the most important employment law case in probably the last 5 to 7 years, the Waxdale case. Essentially, in this case, what happened was the just cause clause in the agreement was found to be unenforceable because it violated the ESA. Both lawyers agreed. This is a court of appeal case in Ontario, and so the company lawyer said, well, I agree it violates the ESA, but that doesn't mean the without cause clause is invalid. And the plaintiff's lawyer argued, the employee's lawyer argued that, well, if one clause is valid, both are invalid, and the Court of Appeal agreed. Court of Appeal said that you can't look at termination clauses in a piecemeal fashion. And if there's a violation of the ESA in one part of the termination clause, in this case, the just cause section, then the entire clause is unenforceable. So the result of Waxdale had broad implications in the employment law community as companies scrambled to have their employment agreements revised and reinforced. And, you know, again, this is an employment law conference. There's probably 10 different employment lawyers speaking. There's probably 10 perspectives. What we've done with our clauses is we've actually eliminated the just cause and without cause distinction. And we've basically said that if you're terminated, it's going to be in accordance with the ESA. And I'm confident that we're covered. Time will tell from the case law, but I'm confident as to where things are at. And the last case I just want to touch on briefly. I know Rishi talked about this case in the context of good faith. The Ocean Nutrition and Matthews case. This is a case that, again, my employer clients have been, challenging me all the time and challenging my staff about all the time. And the key thing about this case is when you terminate someone, that individual is entitled to all aspects of their compensation, whether it be bonus, pension, car allowance, etc. And the only way that you can, carve out that eligibility for common law, elements of common law, is one, to ask the question, would the employee have been entitled to the perk, benefit, pension, car allowance, but for the termination as part of the reasonable notice period? And if the answer to that is yes, you have to ask yourself, does the employment agreement or the bonus plan unequivocally and unambiguously limit that common law right? So it's the Supreme Court has spoken pretty clearly and affirming some previous Court of Appeal cases on this issue. And I think what I would say to the management side lawyers on the line and to all of our clients is make sure that we are referencing proper language, both in the employment agreement and in any ancillary plans, whether it be LTIP plans, RSU plans, benefit plans, bonus plans, and make sure they talk to each other. And there's very, very clear language on what happens in the event of termination, because that's the only way that you're going to be able to carve out that entitlement for the employee. So take a look at those aspects of your compensation. We have about 2 or 3 minutes left. If anyone has any questions, I just wanted to make sure that I left a couple of minutes at the end. And before we get to any questions, and you can use the chat box, there is a, if you use this unique website here, unique link, thank you, Alex. You can claim $50. It's a referral program as part of our My Max rewards. So if you go in and you fill this out, you can claim your gift of up to $50. So I'd encourage people to do that. And I want to know if there's any kind of final questions here before we move on to the panel. Any questions coming in on your end, Alex? Yeah, Paul, I would encourage you, if you haven't already read the Ocean Matthews and the Waxdale case, those are both critical. They're high-level court decisions, so they're going to have, obviously precedent effect, and I would encourage you to, read them carefully. It'll be interesting to see the Waxdale case leave to appeal has already been requested, and the Supreme Court rejected that. So until the Court of Appeal decides differently, that is going to be the law in Ontario.
Hi, Jordan. I just wanted to come on and say thanks for your presentation. It was really interesting, really great content. Unfortunately, yeah, we don't have any questions here, which is too bad. But I see that you have some contact information there. Is that the best way for people to reach out to you?
Absolutely.
Okay, great. And
Absolutely.
we want to just pop your LinkedIn in the chat as well, just in case anyone wants to connect with you there. Or I can grab your LinkedIn and put it in the chat for you. 1 second. But yeah, I just wanted to say thanks for presenting today. It was a really great presentation. Just to let everyone know, so this is the final session for today, and then we have our panel starting at 3:30, which is actually just now. So it's on the main stage there. But thanks again, Jordan. It was a really great presentation.
All the best, everyone.